Well, Jim, very early in your career, you got involved with the organized bar and are still heavily involved with the organized bar. How did that come about and why would you do it? I'm sure you had plenty to do.
Well, I'd say that actually community involvement was really encouraged by my firm, so that made it easy. If I recall, somehow I got appointed as the chair of the legal aid committee of what was then called the Younger Lawyers Section. And we did a statewide survey to determine whether people were being served, and came back with what should be no shock to anyone, that there were a large percentage of Georgians who had no real access to the legal system. Okay. And that was my first involvement
And
at the bar.
that would be back in the late 60s.
Late 60s, yeah.
Mm-hmm. Well, we talked about mentors in the practice. Do you have mentors in the bar leadership roles, people that helped you along, helped you understand how to lead?
Yes, there were fair number of them, but the two real standouts are both Middle Georgians. One from Forsyth, Harold Clark, who just died about 2 weeks ago, and the other one, Cubbage Snow Jr., Macon, Georgia. And they were the folks who really helped me and a ton of other people learn, how to be involved in the bar, how to be concerned about the profession, recognizing that the first thing, you need to be a really good lawyer, because both of them were, and both were just great. We can talk about some of the things where they had my back, because as a young lawyer, I had some fairly unusual ideas, and that continued, by the way, for a number of years.
Through today.
For instance, when I'd gotten elected as president of the Younger Lawyers Section, one of the things I was really interested in, and for young folks who are sitting here, they're going to have no way of relating to this.
All right, just for time reference, this is mid-70s now.
Well, early 70s.
As president of the Young Lawyers.
Early mid-70s. Women were just beginning to come into the practice at that point. I mean, in my class of 120 students in law school, there were 2 women. It was not unusual for there to be no women in a law school class. It was very unusual to have women in law firms. And one of the things that I had done was invited a number of young female lawyers to come to a meeting. I even remember where it was, by the way. It was in a conference room in the National Bank of Georgia building, which filled up 1/3 of a square block, and our firm had offices in all 3 buildings. The doors knocked out and you could go through. In any event, and told them that if they were interested in getting into bar work, which was at that time a good old boy system, and I mean boy, and I guess I could have said good old white boy. I said, I'll be glad to help. That, I can assure that the opportunity you get, you make the best of, but I can make sure you get that opportunity to get involved in bar work. And the reason, what made me think of it, is when you were asking about Cubbage and Harold. Harold was president of the big bar. At the same time, I was president of the Younger Lawyers Section. And so when I disclosed this heretical idea about getting women involved, his and Cubbage's reaction was, it's about time. If you want them appointed to senior bar committees, you just let me know, and I'll take care of it. And those were the sort of things those 2 guys did for a long time, not only that year, but to come.
Well, and I think Justice Clark and Cubbage Snow are going to come up again as we talk about
I'm sure they
things
will.
that came later. But one topic that we need to spend some time on is the creation of Georgia Legal Services in 1970. Does that sound about right? Tell us the story. How did this come about?
Well, in part it was an outgrowth of that Younger Lawyers Committee, in that we had looked at legal needs in the state and saw that they were, really incredible. And by the way, we still haven't solved that problem. There's still many unserved people in the state of Georgia. So, in talking to a couple of friends, Bill I and Phil Heiner, and we said, well, we need to quit talking about it. We need to go do something about it.
Matter of fact, let me put up on the screen here for everybody this photograph of the founders.
Okay.
And that's you with a little bit more hair.
Yes.
Turning around there.
Well, we enlisted three other folks, actually. Tom Dennard, who had been the Younger Lawyers president from Brunswick. Ben Shapiro, who you see in that photo on the left-hand side, and Betsy Neely, who was in the back. And we decided we were going to form a statewide legal services program. Atlanta had had the Atlanta Legal Aid since I think about 1922, founded by a guy named Smythe Gambrell, by the way.
Yeah. But otherwise, in Georgia, there was no systematized provision of legal services to the poor.
No. Actually, one of the office managers of one of the first ones we set up was a guy named Maynard Holbrook Jackson, by the way. So that's how Maynard got his start, was as a legal aid lawyer. But in any event, at this particular time, legal aid was not one of the real popular things among the General Assembly, the Board of Governors. It was not unusual to hear people say, we take care of our own. And what that meant was that if my maid's child gets in trouble, I will take care of it. That's how we take care of our own, not considering the fact that most folks who didn't work for lawyers weren't going to have any legal help at all. Now, there were a lot of lawyers who did pro bono work on their own. When somebody really needed help, they would do the work, Atticus Finch. But it wasn't nearly enough, so we decided we were going to set up this legal aid program. And I say it was not particularly popular, to the point of I've been called all sorts of things over a number of years. At that point, it was pinko commie.
Would it be more fair to call you young and naive, idealistic?
All of those probably fit at the time, but we really wanted to cause this to happen. So we get together and we decided we were going to set up what was then called Georgia Legal Services Programs, GLISP. But we needed some help, and that's where the folks like Cubbage and Harrell come back in. They were very active in bar work at that point. And this is something that was going to have to get through the Board of Governors. In fact, people don't even remember that the original Board of Directors of Georgia Legal Services was the Board of Governors of the State Bar.
Really?
That way they knew they had total control. Fortunately, in the incorporation documents, we provided for an executive committee, which would meet in between Board of Governors meetings. And as you would guess, that's where decisions like whether to file class actions against banks and other things like that took place. And the only way we were able to make this keep working was, and again, this comes back to Harrell and Cubbage and Gus Cleveland and Sonny Seiler and others, that as you may know, at the annual meeting of the State Bar, one of the things that you have in this first session is that you go through with all of these resolutions that are necessary to appoint an auditor and bonds people and all sorts of other things. And the board is just sitting there and saying, aye, aye, aye. And I would make a motion to approve all action taken by the Executive Committee of Georgia Legal Service Programs in the previous 3 months. And you'd have a shill who is there saying second, and All in favor, aye. All opposed, no. It just went on so for several years. Unfortunately, statutes of limitation, I'm sure, have long since expired. So I can tell these, and the Board of Governors was just approving all these things that if they had a report,
Right.
most of them, of course, had not read the report, but some of them would have been absolutely appalled at some of the wild things these legal services lawyers were doing. And the ones that got the publicity were class actions. Where the real help was somebody who had a problem, landlord-tenant problem, or any number of other problems. And to that person, that's the biggest legal problem out there. And so the folks who spent their careers solving those problems, I have a lot of respect for them.
This was obviously something that was personally very close to your heart and very important to you, because you took on some opposition and with help overcame it. Personally, why was this so important to you?
Well, as I say, we had taken a look at it, and it was so clear that it was needed. People needed legal help. They couldn't afford it. As a sideline, the cost of legal services, when I do CLEs now, I'm often asked, or tempted to ask, that you're talking to an audience of lawyers, 150, 250 lawyers, and say, if you had a serious legal problem, how many of you could afford to hire your own firm? You look out in the audience and there are no hands going up. These well-paid group of people could not even afford to hire their own law firm. There's a real need, we need to figure out, still need to figure out how to do it. But at that point, it was the sort of thing that you look back now, what's that been, at least 10 years?
A lot more than that, Jim.
Oh, a little longer than 10 years, and you're really glad you were part of. Because close to 1 million people have gotten legal services who wouldn't have gotten them otherwise.
That's remarkable.
You can feel good about it.
How did the firm feel about your involvement in that particular effort?
Well, as I say, they were very supportive because of the fact that they recognized that a lot of things were changing, a lot of things needed to change, and that we ought to be in the forefront of that. In terms of hiring female lawyers, black lawyers, I think our firm was, if not the first, one of the very first in the Southeast to do both of those, and it was done because it was the right thing to do.
In that same spirit, if you don't mind me taking something a little bit out of order, you told me a story about Martin Luther King Jr.'s funeral procession, and you were there. Would you tell that story?
Well, I claim that you can see me in one of the photographs that was taken from some aerial spot, walking behind the mule-drawn wagon. And I was there, but I'm not sure I can pick me out of the crowd. But it was, a very touching thing that here this charismatic leader had been taken out. And I felt like I ought to be marching in that procession.
And when you got back to the office?
Interestingly enough, everybody in the firm knew it, and I'm sure there were several other lawyers who did it. All three of the named partners came by to say, thank you. We needed to be there.
Yeah. Well,
that made a lot of this stuff a whole bunch easier.
Yeah. Yes, it does. Well, in the same vein as we're talking about the firm's involvement and the firm's reaction to your various activities, I won't call them commie pinko activities, but that's you. I want to ask you about a few other things. You've spent most of your life, almost all of your professional life, in transactional practice. You did have a few exposures to litigation.
Oh, no, I'm telling you, I was just an incredibly successful trial lawyer. You know, in all modesty.
How many cases have you lost, Jim?
None. Not a single one. Have not lost a civil case. Have not lost a criminal case.
Okay.
As an example, in my first year of practice, second year maybe, I get this call from Charles A. Moy's courtroom, Judge Moy, federal district judge, to explain to me how fortunate I was that I had been assigned to represent an alleged bootlegger. So I go to see Judge Moy, who I knew.
Now, this is at a time when young lawyers were just appointed
to
handle the indigent criminal defense.
Yeah, that was the way indigent criminal defense was done. You just took the youngest people in the bar. I bet there's some folks sitting here who remember when they started out that they got some of those appointed cases. So I went over to see Judge Moore, and I said, Judge, you know, I don't know anything about criminal practice. And he said, I know that. And I said, well, the first thing we're going to have to file is a motion for inadequate counsel.
About yourself.
About me. And he smiled, and he said, well, that would not be timely. You know, you may want to file that after the case is over. And I said, well, we could avoid all that if you just appoint somebody else to represent this person. He was not really interested in that as a possibility and sent me off. And so I go back over, and this was at a time when law firms actually had libraries. These are books that are shelved, you know, in order or whatever.
I remember those.
You didn't have something you could call all that stuff up. Well, fortunately, there was a book in the Alston, Miller & Gaines library that says how to try a criminal case in federal court. Well, I memorized that thing. Read every bootlegging case that I could find. That means the Northern District of Georgia, the Western District of North Carolina, and the Eastern District of Tennessee took out about 90% of those cases. So I felt like I'd become a real expert on bootlegging.
The bootlegging cases.
Cases. Had wanted to interview my client, and this was while I was still in the Air National Guard, and I said, I want to come up after drill weekend to interview you and your two alibi witnesses who claimed to be with him at Lake Lanier fishing at this time. And he said, well, are you going to be wearing a blue uniform? I said, well, yeah. And he said, maybe I better meet you in town, which gave you a little feeling about what was going on. In any event, I met his two alibi witnesses, and I'm sure those of you who've seen Deliverance would feel right at home. Cigarette rolled up in the T-shirt, you know, missing teeth, the whole bit. And fortunately, I don't know why it occurred to me to ask, because have either of you guys been arrested? Yeah. Have either of you been convicted? Yeah. For what? Bootlegging. And I thought, well, there go my alibi witnesses. We didn't call them, by the way. But we had the trial. It was not before Judge Moy. It was before a visiting judge from California, who, when I had my person on the stand trying to refute the fact that the revenue agent said they saw him from the front of the pickup truck, that he was in the back of the pickup truck unloading apples. The judge looks at my client and said, this is really interesting. How do you make Applejack? And so I leap up, say, may I approach the bench? And I go up there, and as I'm walking up, it occurs to him what he's just done. So he agrees that he will either give me mistrial on the spot, or after the jury comes back, if I could reassert that motion. So we let it go through, and the jury comes back with not guilty. And I have a clear explanation for that, is that the jurors felt so sorry for my client that he had me as his lawyer. There had to be a sympathy factor there somewhere. But in any event, the U.S. attorney looks at me and said, I'm really curious about something. So you kept referring to these two folks that he was fishing with. Why didn't you just call them and put them on the stand? I said, John, believe me, I had a good reason. And he smiled and he flipped over 2 folders. He was just waiting. You know, he had their records there.
Their resumes.
Their resumes. So, I have never lost a criminal case.
Now, wait a minute. The judge did learn how to make the Applejack, though.
Well, after the jury had come back and the case was over, I asked my client if he would go up and explain to the judge from California how to make Applejack.
God bless double jeopardy.
Absolutely. So
right.
I've never lost a criminal case.
All right, because that was the only one.
Every one of them I've tried, I've won.
All right, 1 for 1.
1 for 1.
All right, civil cases.
Oh, civil, yeah. This was another one. Tried for a group called the Lawyers Committee for Civil Rights Under Law. Again, not one of the more popular groups at the particular time, but it was right after the '68 Civil Rights Act had been enacted. And the idea was to find a test case to test the constitutionality of the act. We had really experienced counsel. A guy named David Crossland, Archer Smith, and I had at least 6 years combined private practice experience. And the nice thing on these is, you know, you pick a plaintiff who has all of the facts. I mean, just a slam dunk on the facts. So we try this as a non-jury trial, thank goodness, to this nice fellow named Sidney Oslin Smith, who also later was a law partner. But Sid Smith, one of the really class people in the world, overlooked these inept attorneys and ruled that yes, the '68 Civil Rights Act was constitutional. So we patted ourselves on the back that we had been involved in a constitutional law case, and that ended my civil experience, but 1 for 1 again.
Yep.
And the only other appearance was before the Georgia Supreme Court. And that was to argue in favor of something called IOLTA.
Well, we're going to get to that, but I suspect from your introduction that you won.
Oh, yes.
All right, so there's a little foreshadowing there. But again, going back to the Lawyers Committee for Civil Rights case, I mean, that you're talking about the constitutionality of the Voting Rights Act.
Well, this was fair housing.
Fair housing, okay. So, and this is the 60s in Georgia, and your firm is still supporting these efforts.
Yep. Okay. Very fortunate.
Yep, you are very fortunate.
I will tell you there were several times when I had one of the senior partners come by and say, you know, as a young lawyer, I don't think I would have done that, but I'm damn glad you did.
Okay, that works.
So you really felt comfortable in doing some things that were a little bit on the fringe.
Well, we've been talking about a lot of things other than the practice of law, the real estate practice that you had. But meanwhile, I trust you're spending most of your time, your professional time, representing clients, doing large commercial deals. Describe that practice for us. I mean, Atlanta was growing, Atlanta was changing. And I sensed that this was a very exciting time to be doing what you were doing.
Oh, it was.
Tell us about that practice, what exactly you did, and what it was that you liked about it.
Well, again, it was something we alluded to earlier in that the best thing you wanted on the other side was a really good lawyer. I mean, the last thing you wanted, the next to the last thing you wanted was a brand new lawyer on the other side, because they didn't know what they were doing and what they could and couldn't give, and it took forever. The worst thing was to have an experienced lawyer on the other side who had no experience in doing commercial real estate. They were even more terrified they were going to make a mistake. The best thing was when you had a really good lawyer on the other side. But you could sit down and put together a complicated deal over a period of time, make it work, cure problems, and have just financed, Phipps Plaza or whatever. It was a lot of fun. And it really sort of fit me in the sense that for, I guess, a decade or more, for instance, I sat on the board of a British company that had about $1.2 billion worth of real estate assets in the U.S. Now you would never have one of your partners as a board member of a major client. At that time, I was the board member, but one of my partners was there as the lawyer. We thought that clearly divided the roles, that Laura was the lawyer and I was the board member. But I absolutely loved being a part of the deal. That was the fun part, is the deal. And having younger lawyers who then memorialized that deal in 18 inches of paper.
So you were the big picture guy by this point.
Loved the forest.
Not the trees.
But had spent a long time dealing with the trees before you got to that point. But it made it just a really fun practice.
What was the hardest part about it? What was the most challenging part to it, other than having an inexperienced lawyer on the other side?
Well, inexperienced are one of those lawyers that I used to refer to as tie jerkers. You go into a session and they're jerking your tie about what was going on. And one quick story about that, a number of my clients, large number of my clients, were not based in the United States. Most of them were based in London. But when the money was wired, it tended to come from Riyadh or other places. But in any event, I met the client. And it was great fun, by the way, working with this client in the sense that you'd fly into LaGuardia and there would be somebody there with a light gray suit and a cap on holding up a sign, Elliot, and he grabbed your hanging bag and your briefcase and took you out to the waiting limo and downtown for whatever. So it was living on a side that you were not really totally used to, but it was lots of fun trying to get there. But in any event, we go into this meeting. This happened to be at a time when the market, real estate has always been cyclical, and this was a downtime in New York. Somebody who wanted to sell an office building. My folks could buy it for cash. They were not interested in where they could get a loan. We go into the room, and the lawyer on the other side starts off the meeting by saying, "Let me tell you people, the following 5 things are not negotiable." And he lists his 5. My client looks at his watch and says, "Jim, if we're going to make our flight, we really need to get to the airport." Now, our flight was 3 days from that point. We walked out with the other client racing down the hallway saying, "What's the matter? What's the matter? I thought we were going to talk about a deal." We go back to the hotel. By the time I get back there are about 6 phone messages, and there's only 6 blocks. And these people are saying, "What do we do? What do we do?" And I said, "You go look for another buyer." Said, this fellow is used to starting off a transaction by spending the first day or 2 talking about family and whatever. In the Middle East, you don't start off. These 5 points are non-negotiable. Mm-hmm. And so we ended up, having a nice lunch and moving our flights up. And he flew back to London, and I flew back. So dealing with lawyers on the other side who were like that. Periodically, you would deal with folks, fortunately on the other side, who were less than honest.
In what way?
You'd have somebody, for instance, they would tell you all sorts of things. When you got in the due diligence, you would find that there was very little correlation between truth and what they had told you. And of course, that's so short-sighted because you're going to find it out, and the deal's going to either collapse or it's going to get renegotiated. And I just had this weird inclination. I like dealing with honest people on the other side. It was really sort of nice to deal with honest people on the other side.
Well, you were obviously very successful at it, and at the risk of asking you to brag about yourself, I wonder if you could tell us what you think the key to that success was. If you've got, somebody watching this, listening to it, who thinks they love the deal, they want to be a deal doer, they want to do the kind of things that you did, and they want to be successful at it.
If you want to be a deal maker instead of a deal breaker, you've got to recognize that a transactional practice is adversarial, only to the extent that you're representing your client, you want to do the best job you can. The other lawyer wants to represent her client the best she can. But both clients want to get to a deal. That law school profs, sometimes we may have the tendency that we teach our students that what's important in a deal are the legal issues. And sometimes they are worth 2% of what's going on. It's the money. Your client wants to sell a shopping center. Mm-hmm. My client wants to buy a shopping center. The only way you and I keep our clients happy is we figure out how to make the deal work.
So you see the deal through the client's eyes.
Oh, yeah. In fact, I even tell students now, take a close look at the deal. Pick out the 5 things that are important to your client. The most important things. Now, put another hat on. Look at the 5 things that are the most important for the other side. You now have the only 10 things you need to talk about. Don't give me any argument over whether a notice provision is 30 or 45 days. That doesn't make any real difference. Get to the important things, get them done, and make a deal.
We're going to talk in a few minutes about some more bar activities because, of course, eventually you become president of the State Bar of Georgia. But you had an earlier opportunity to try to take that step earlier in your career, and you made a very conscious decision not to. Could you talk a little bit about that decision?
Yeah, one of the things that happens in any sort of volunteer organization are there are essentially chairs. You move along. And after being president of the Younger Lawyers section, I sort of moved through secretary, treasurer, whatever, and was planning a run. And some of my partners came to say, our business is growing so fast, we can't afford to have somebody who's going to take half of its time for 3 years to do bar work. We'd really appreciate it if you don't run. So I did not run. Was disappointed. I felt like it was all set up, ready to go. But they were right. The firm was growing like crazy. We were all in there, in spite of what I'd been told as a first-year lawyer, on Saturdays and some Sundays. And there was a lot going on. And then, fortunately, 8 or 10 years later, Sidney Smith comes in and sits down and says, we think we made a mistake. Philip Alston was president of the State Bar. How can we say, with a firm our size, and at that point, this huge firm was 250 people, can't afford for one of our partners to be president of our profession. So I got back involved, got elected.
Which takes us to one of the big issues and stories that I want to make sure that we cover. You mentioned it earlier, and that is the controversy over interest on lawyers' trust accounts, which to the unsophisticated ear sounds about as like the most boring subject you could possibly talk about, and nothing is further from the truth.
Oh yeah, it is $100 million boring, which is how much money IOLTA has raised since it was started. Georgia had a voluntary IOLTA program in the 80s. And it wasn't raising any money because lawyers, frankly, didn't want to fool with it. Their banking clients loved the non-interest-bearing accounts that trust funds went into. There was not an overwhelming desire for IOLTA being mandatory.
So just to back up for a minute, this is using the interest on the lawyers' trust accounts to fund activities and to fund, for example,
Could be
representation.
used for charitable purposes, because of course the lawyer could not use those
Right.
funds. They need to be remitted to clients, and so most law firms didn't put it in interest-bearing accounts because that created a real administrative hassle of determining at the end of each month who got what. Well, the banks loved it, man. When you're talking about cost of funds, you love those not interest-bearing accounts. Well, and this was at a time when the economic support coming from the federal government was waning dramatically for legal services. And so, cohort in crime, one Cubbage Snow Jr., and I were talking one day that we were really concerned that legal services may go under. General Assembly was not interested in funding it, particularly. Congress was cutting the funds almost every year. We were not the first. Other bars had come up with IOLTAs. So Cubbage and I made an appointment and went to see three folks on the Supreme Court. Tom Marshall, who was the chief, Harold Clark, who was the PJ, and Charles Longstreet Weltner. And we talked about IOLTA and how desperate legal services was for funding and how much money this could raise. And so Tom, Chief Justice, says, how long will it take you to get this through your Board of Governors? Meaning, so that the bar was asking the court to do this. And I said, I'm guessing between 30 and 35 years. And he said, no, I'm serious. And Harold, who had been a bar president, said, Tom, he's serious. And he said, well, are you two, meaning Cubbage and me, asking this court on its own motion to require all lawyers to use interest-bearing trust accounts? I said, yes. So they agreed, by the way, to have a show cause for why IOLTA shouldn't be made mandatory. The difference was where it was maybe earning $50,000 before, it started earning $5 million a year, most of which went to legal services. But again, of all the people in the world that you're trying to tell to do something, last group you want to take on are lawyers, right? Telling them they got to put their money in interest-bearing accounts. Their clients, who are generally the banks that they're putting the money in, don't want to give up those non-interest-bearing accounts. So it was not very popular, and once the show cause order was issued, I was just stunned at the number of phone calls I was getting. Why am I getting the phone calls, right? So I finally call over to the chief's office and just chatting with his secretary. I said, I just feel sorry for the chief. He must be getting thousands of these calls because I'm getting a whole bunch, and I don't know why people are calling me.
You didn't issue the show cause order.
I didn't issue the show cause order. In fact, nobody knew that Cubbage and I had gone over there to ask for it, as far as I knew. And she sort of giggles, and you get this sense she knows something. And I said, what's going on? And she said, well, the chief is giving me strict instructions that when somebody calls, if I can tell that they are unhappy about this, I'm to tell them that the court has appointed you to take comments on this and for them to call you. And if they're really happy about this, put the call right on through to the chief. And he had done that, by the way. But in any event, there was a lot of opposition to it. The Georgia trial lawyers, very politically savvy group, had come out absolutely opposed to it. So I had lunch with 3 of their officers, and we cut a deal that their foundation would get 25% of the money raised. Now keep in mind, I probably did not have authority to make deals on behalf of the Supreme Court.
Probably isn't the word.
Probably didn't have that authority, but all of a sudden the GTLA does a 180. They are now all in favor of it. The deal was, if I write you in for 25%, will all of your officers be there to support it? And the answer was yes. All right, now, one, I got to tell Cubbage about it, who initial reaction was not totally positive. You did what? Then I had to get an appointment and go see my three buddies on the court. And so we sit down, and again, it's Tom Marshall, Harold Clark, Charlie Weldon. And I said, Chief, got a confession to make. And I told him what I had done. And he leans up, across his desk. He said, you did what? And I said, I believe it was necessary to make this deal. And I don't remember whether it was Harold or Charlie, but one of them said, Chief, politics is the art of the possible. And he sat back and said, it's done. So we had the show cause hearing, and virtually everybody who showed up was in favor of it.
So this is your one Georgia Supreme
That
Court
was
argument?
my one Supreme Court argument. And it was fun. George Smith, for instance, was one of those, and I'm getting up making my presentation, and he interrupts. He says, Mr. Elliot, you're not going to give me the poor country boy argument, are you? And I stepped back and said, why, yes, Judge. Is that not going to work? And he said, no. So I make this elaborate, I didn't have any poor country boy argument in there. It went on, and you can see the other six just duck their heads as they're grinning.
So you mark out on your argument.
Oh, yeah.
Your pad.
What's this dirt lawyer doing up here making an argument to the court? But that was my third appearance, and I'm now 3 for 3. Fortunately, the Georgia Supreme Court adopted that, and it has raised over $100 million, $75 million of which has gone for legal services. So that million Georgians who've gotten legal services wouldn't have gotten them.
So it was
without
one
the
thing to
court
set up
doing
the
this.
organization, it's another thing to make sure they had the money.
Yeah.
Absolutely.
And for the last 3 or 4 years, unfortunately, IOLTA funds have dropped off. But he was really pretty courageous for the court. Keep in mind, they are elected. And they were doing something they knew was not popular with the bar. But they also knew it was right. And they stepped up and voted 7-0. Let's do it.
Well, why don't we take our second break, and we'll come back in a few minutes.
Very good.
Okay, thanks.